Good morning. Today we are going to discuss about the nature of tort. In the last lecture, we have seen the definition of tort. So, when a plaintiff, that is the person who files a case, and the defendant means the person against whom the case is been filed. The plaintiff, when he files a case in a court, he has to prove that the defendant has done a tort. We'll just revise. Tort is a civil wrong which has been filed for compensation. The most important remedy in tort is compensation. And what is a tort? It is something twisted. It has been derived from the Latin term tortum, that is something wrong. Okay, now these wrongs are what? Breach of a duty. This duty is been fixed by law. So, law fixes certain duties for all the people that they have to follow it. But if they don't follow it, it becomes a wrong. It becomes a tort. And the victim has to file a case in a court asking for compensation. This is a general meaning of tort. Now, today we are going to discuss about the nature of the tort. A question regularly arises that what exactly a tort is, what is its nature, that whether it is a specific tort or whether new tort can come into existence. Now there are two different schools. Schools means the way of thought. Salmond and Frederick Pollock, they two are the proponents of the first school. The first school states that law of tort is law of torts. I have added here S. Law of tort is law of torts. Specific number of torts. Therefore, you have to file a case for the concerned defined tort in law. We'll take an example. We'll take an example of a crime. Okay. Now, see, in the penal code, in the criminal laws, specific crimes are being defined, like murder, theft, criminal misappropriation, then cheating. These are different types of crimes. They are being clearly defined. In all the criminal laws, the crime is being defined. They have mentioned about the essentials of crime. Like for a murder, what is required? When you can call it as a murder? When you will call it as a culpable homicide? When you are going to call it as a theft? Therefore, specific number of crimes are there. Take 100, 200 crimes are there which are being defined in the criminal law. But if some wrong occurs, which is, or some crime occurs which is not in the law, what example we took? We have taken like 200 number of crimes are there. Different kinds of crimes, 200 are there in law. Example, they are already more than that, but we are just taking an example that 200 crimes are there. But if a person does some crime, that is 201, it cannot be called as a crime because it is not defined in law. Therefore, a person who has done that illegal act, that unlawful act, you feel like calling it as a crime, but law has not explained it as a crime. Maybe afterwards that wrong, that 201 wrong, maybe may come, you can say, may come in a criminal law. Thereafter it will become a crime. Thereafter only it can be punished. But before that, when actually that wrong occurred, which stirred up a movement in the country, which stirred up a movement and compelled the parliament to name it as a crime, that concerned crime will go unpunished because at that time it was not a crime. So, as in criminal law, there are specific number of crimes. If a person does that, he'll be punished. But if he does something else, he'll not be punished. But that something else may be named as crime afterwards, but it is not a crime because it was not in the law. Same concept is explained by Salmond and Pollock in their first theory. This is the first theory, which says that law of tort or law of torts, a specific number of torts. If a person does that, then he will be liable. But if he does something else, then that is not a tort, because it is not explained in the law. So what will happen if a person does some wrong? If it is not a tort as per law, he will not get justice. He will not be liable. The victim will not get justice, and the tortfeasor will not be liable, because it is not a tort in a law. Thereafter it may be called as a tort. For explaining this, Frederick Pollock has named his own theory as a pigeonhole theory. For explaining to you again the crime and that wrong and that tort, I will tell pigeonhole theory of Pollock. What he says, take an example, 100 pigeons are there. Therefore, for 100 pigeons, what the owner has done, that owner has made some 100 holes. In a wall, he has made 100 holes. Each and every hole is for each and every pigeon. Therefore, he is having 100 pigeons. Therefore, he has made 100 holes. What happens? The pigeon will come and they will fit in that concerned hole. But one day what happened? Some other pigeon comes. Means 101 pigeon is coming. That 101 pigeon, that one pigeon will remain outside, because he is not having a hole in the wall. Getting it? 100 pigeons are there, 100 holes are there. The 100 pigeon will fit in the hole, but that one pigeon will not fit because he is not having a hole. So what Pollock is telling, see, if a new tort occurs, it is not a tort, because it is not having the hole. It is not defined. Therefore, you are going to get unredressed. The plaintiff will not get compensation. This is the first theory telling about the nature of tort. That I'll again repeat. The nature of tort is, according to them, is a tort is a specific number of torts. New tort occurs, it is not a wrong. This theory was criticized, and therefore another theory came into existence, which is our second theory, which has been explained to you, or the proponent of the theory is Winfield, Percy Winfield. This is the correct theory, this is the correct view. What he says, law of torts, he's telling law of torts is law of tort. Each and every wrong, whenever a wrong occurs, it is a tort. Something twisted happens, it is a tort. Therefore, if something new happens, you have to give him remedy, you have to give him justice, because he is not having proper justifications to explain to us what he has done. So, he will be liable. According to this theory, new tort will come into existence and they will be recognized. Nobody will go unredressed. The plaintiff will file a case, tell, see, the defendant has done this wrong, something new maybe, so this wrong. The court will also say, yes, this is something new, however, he is a wrongdoer, he is not having proper justifications for that, and therefore this tort will be recognized from that particular case, and the plaintiff will get compensation. The plaintiff will not go unredressed, he will get compensation. That is the object of law of tort, to give compensation or to give solutions or to give remedies to each and every person who comes for justice, because the defendant is also not having proper justifications, proper explanation. This theory is the proper theory which we recognized in the law of torts. This theory, you can say, was also applied in Ashby versus White. This is a famous case in law of torts. In the next topic also, this theory is there, is an important landmark case. In this theory, what has happened? The person went to election booth for voting. He was having all the papers and all. He was not like he is not having certain things. He's not having papers and all. That was not the case. He was having everything. He was eligible to vote. But the rotating officer did not allow him to vote. So what happened? He could not vote, and therefore he has filed a case. Here his right has been violated. If his right has been violated, he will get justice. This comes into existence because of the second theory. The rotating officer has done a wrong. Before this case, such a type of thing was not there, like right to vote, to be recognized. Today we know everything. Today we know our rights and all. But at that time, right to vote was not discussed anywhere before that case. Okay. Therefore, right to vote was first time recognized in Ashby versus White because the rotating officer was not in a position to explain that why he didn't allow the plaintiff to vote. Moreover, the person whom he wanted to vote, or the contestant whom he wanted to vote, he only won. He won the election. So as per, you can say, the common parlance, no wrong or no damage had occurred. Though no damage had occurred, the court has held no. Legal injury has occurred. Legal injury here is right to vote has been violated. Therefore, he has to get justice. So, new torts will be recognized in law. They will be given justice. The defendant will be made liable because of the second theory of Percy Winfield. Salmon and Pollock, they are the proponent of the first theory, which say law of tort is law of specific torts, while Percy Winfield's theory, that is the second theory, that says law of torts is law of torts, many number of torts, unlimited, infinite number of torts are there, which we are going to recognize. Don't name it also. Though they are unnamed, for the first time we are going to recognize them to give justice. Understood? Okay, bye bye. See you in the next video.